Help Hire managed to get their claim struck out not once but twice, and the second time round suddenly came up with the wheeze, oh well sod it, we'll accept the defendant's Part 36 offer that they made some time ago. Unsurprisingly, the High Court judge in that case decided that once you're struck out, you can't accept the Part 36 offer. The Part 36 offer effectively becomes dormant during the period that you're struck out. Nice try, but no cigar. What I'm going to talk about is something a little bit more technical, and that is the consequences of late acceptance of Part 36 offers, which sounds as though it's quite dull and sounds as though it's quite specialist, both of which it is, but it's also of quite general application to all of us. Because whilst we all know that one view of Part 36 is that it's a facilitative code, it enables the parties to bring claims to mutually beneficial and satisfactory conclusion, the truth is that it's really a defendant's tool, because in quantum-only cases, what it enables a defendant to do is reverse the risk of trial. In a case where liability is either obvious or not in dispute anyway, the claimant's effectively getting a free hit at the litigation. They bring their claim and they know they're going to win it. And so Part 36 offers a defendant the opportunity to reverse that risk, because once the Part 36 offer is made, if the claimant doesn't beat the offer, then the defendant recovers their costs. In most cases, that's not a great problem, because in low-value cases, in cases where the injury crystallises quite quickly, recovery is made quite quickly, or indeed in some very catastrophic cases, where the extent of injury is obvious at quite an early stage, then both parties are in a position to value the claim quite quickly. But there's a certain kind of claim where it's quite a mischievous device. There are some cases where the claimant's prognosis won't be certain for a considerable period of time. And in those cases, an insurer can take an educated guess at the value of the claim and put pressure on the claimant, whereas a claimant's solicitor is put in a much, much more difficult position. It's very difficult to explain to a claimant with serious injuries and whose prognosis is uncertain that, well, I've done loads of these cases and they're all worth around about this, and we can take this sort of punt on your case. Apart from anything else, just picking up from where David finished off, it's going to expose you to a potential liability to your client when your advice on a wing and a prayer is incorrect. And we also know that it's a tactic that defendants use and use regularly. In the case I did last year, I was instructed to go to a meeting with insurers very early on in a case in respect of a brain-injured claimant, total right-sided hemiparesis, and wheelchair bound. We had a neurologist's report. The defendant had one neurologist's report and a care report. I think we were about 15 months post-accident, and they offered her £1.6 million at that meeting. We were in no position to advise her in any detail, but the real mischief of it is that when I went in to go and say to the insurer, look, there's no way I can advise her to accept this offer, and she's not going to accept it until we've got further evidence, his immediate response to me was, well, how much do I have to make as a Part 36 offer before you squeak? And of course, we were in a really threatened position at that point. We had lots and lots of pretty expensive investigation to carry out. And if he'd made that as a Part 36 offer, we'd have been carrying out those investigations with a costs risk, which I suspect most claimant lawyers here would think is unfair. Now, in the last 12 months, that question's arisen in the High Court and the Court of Appeal on 3 occasions. And this is where the position arises. Part 36.14 relates to the cost consequences where the claimant fails to beat an offer at trial. And where the claimant fails to beat an offer at trial, unless the court considers it unjust to do so, they will order that the defendant's entitled to their costs from the date when the relevant period expired. We don't have the same position in 36.10 where you accept the offer late rather than losing at trial. 3610 says that where the Part 36 offer is accepted after the expiry of the relevant period, if the parties do not agree the liability for costs, the court will make an order as to costs. And unless the court orders otherwise, that order will be that the claimant will be entitled to the costs of the proceedings up to the date on which the relevant period expired, and the offeree will be liable for the offeror's costs from the period from the expiry of the date to the date of acceptance. So there's clearly a discretion there for the court to make a different costs order than that, but there's no guidance in the rule itself as to how that discretion should be exercised. The first of those cases that came to the High Court was a case called Lum and Hampsey, and in that case the claimant asked the High Court judge to exercise her discretion to award him his costs, having accepted the defendant's offer of £900,000 14 months after it was made and less than 2 weeks before the start of the quantum trial. There was some previous authority on the issue in Matthews and Metal Improvements and Kunaka versus Barclays Bank, but both of those cases were in respect of the old Part 36, in which 3610 or its then equivalent was differently worded. But from those authorities, the High Court judge concluded that her discretion was to be exercised as though it was equivalent to the discretion in Part 3614. In other words, the ordinary costs order would follow unless it was unjust to do so. And she would then consider, in considering whether it was unjust to do so, the matter set out in 3614.4, namely the terms of the Part 36 offer, the stage in proceedings when it was made, the information available to the parties at the time that it was made, and the conduct of the parties with regard to the giving or refusing to give information. In Matthews and Metal Improvement, it had been suggested by the Court of Appeal that there was a need to prove exceptionality, in other words, that the case was exceptional before a different order would be made. And the judge in Lum said that all that really meant was that such a departure from the ordinary rule would be the exception rather than the rule. She then applied her discretion, limiting her discretion to the 3614 requirements, and she had regard to, in particular, to the following factors. Firstly, at the time that the defendant's Part 36 offer was made, a considerable amount of medical evidence had been obtained by both parties. In fact, there'd been a complete round of all expert evidence, including care evidence at that point. She also took into account that the outstanding issues that might affect the claimant's prognosis. Now, those two particular issues in that case were, firstly, that at the time the offer was made, the claimant had just started residential neuro rehab and the collapse of his marriage was imminent, were ordinary contingencies of litigation, and they weren't enough to dispel the ordinary costs order. But in my view, by far the most important factor that she took into account was that she didn't accept the claimant's assertion that this was all unfair and that at the time that the offer was made they weren't capable of valuing the claim. In fairness, their argument to that extent was somewhat undermined by the fact that prior to the offer being made they'd attended a joint settlement meeting, the details of which were before the judge, including the fact that the claimant had made offers, and further that they made their own Part 36 offer only a few months after the defendant's offer and at a time when he was still undergoing residential neuro rehab and his marriage hadn't yet collapsed. SG and Hewitt was the second case that came before the High Court judge, and in that case the claimant, an infant claimant, asked the judge to exercise his discretion to award costs, having accepted the defendant's £500,000 offer 2 years after it was made. The claimant in that case argued that the ordinary costs order would be unjust because he couldn't value his claim at the time, and he had pretty good basis on which to say that. The neuropsychologists instructed by both of the parties said that they couldn't give a final prognosis in respect to the claimant, who was 12 at the time, until the ordinary consequences of adolescence on his neurodevelopment had had the opportunity to impact upon his neuropsychiatric condition. Mr. Justice Popplewell accepted pretty much everything that the claimant said in respect of their difficulties. He also noted that in that case, on receipt of the offer, the claimant had immediately written to the defendant to say, we can't consider this offer at the moment because the prognosis is too uncertain. He also bore in mind that at that time, the claimant then spent all of their time addressing the offer. And in the additional medical evidence that they then pursued over that 2-year period, all of it was to do with whether they could get a final prognosis and consider the defendant's offer. Nevertheless, he relied on Matthews, he particularly relied on Lum. He decided that the defendant was entitled to the protection afforded by Part 36. The case was not an exceptional one, and he wouldn't permit departure from the ordinary costs rule. And then the third case was PGF and OMFS, a case before the TCC. It's a dilapidations case under a commercial lease, and the claimant sought to accept the defendant's offer of £700,000 9 months after it was made. In that case, the recorder did depart from the ordinary cost consequences, but on a very narrow reason. He didn't find that they satisfied some exception to the ordinary rule under Part 36.10, but he did find that the defendant had unreasonably refused a request for mediation after the Part 36 offer had been made, and therefore a different costs order was made because of that unreasonable failure to attend mediation. In early 2012, permission was given for both SG and Hewitt and Lum and Hampsey to go to the Court of Appeal, and they were due to be heard together at the end of July. Unfortunately, Lum was compromised before it proceeded to a hearing. And it's unfortunate that that took place because without the additional decision of Lum from the Court of Appeal, I think we've got a less than clear position from them. In some ways, unsurprisingly, the Court of Appeal reversed the decision in SG and Hewitt. They took the view that the discretion afforded by 3610 was an important one. Lady Justice Arden made the point that it must be a deliberate and important safety valve, and therefore they took the view that there must be a relatively broad judicial discretion. Lady Justice Black said, I don't think it's wise to attempt to prescribe or restrict in the abstract the circumstances in which the court may reach the conclusion that it's unjust to make the normal order. And they then went on to consider various aspects of the case. And they took into account various elements. Firstly, the claimant's incapacity. Secondly, that the claimant was acting entirely, not just reasonably, but on the basis of medical evidence in rejecting the offer at the time that it was made. Thirdly, that it would have been impossible for the claimant in that case to obtain court approval of any settlement if they had tried to accept the offer. And fourthly, that the offer was made before proceedings had even been issued. The claimant was still so young that he could have waited until after adolescence. He could have then had an accurate prognosis, and then he could have considered the defendant's offer. And that in those circumstances, it would be unfair to hold him to the defendant's early offer. So the decision in SG and Hewitt is great if you're a claimant lawyer, because it moves away from the hard position that appeared to have been taken by the High Court at the end of last year. But it raises as many questions as it answers, as any case will, that asserts that there's a broad discretion. Effectively, what the Court of Appeals say in SG and Hewitt is it's a broad discretion and therefore everything's up for grabs and you can argue anything that you like. And I think it's a shame that Lum wasn't heard at the same time. My own view is that if it had been, Lum would have survived. And I think the reason that Lum would have survived is that I think the Court of Appeal would have seen through the judgment and seen that what was really behind the High Court judge's decision there was that she didn't believe what the claimants were trying to tell her at the costs hearing. She didn't believe that they were really in any difficulty in valuing the claim at the time that the defendant's offer was made, that actually what they did was they simply gambled on the defendant increasing their offer at some point between then and trial. Effectively, they decided to play high-stakes poker, and they lost. Without that balance to the Court of Appeal's decision, I think what you're left with is this kind of open-ended discretion. And I think what you'll see is the arguments that were raised in Lum will still get brought forward in these kind of arguments. And you will still have disputes as to what should or should not be taken into account in the discretion. So yes, SG and Hewitt gives us the discretion, but they do emphasise that these items are, that decisions in cost cases are very, very fact sensitive. And that then leads us on to, well, what are the potential consequences of this little course of litigation? And I think that the consequences could be quite significant, and they might not be to the benefit of any of us, whether you act for claimants or defendants. At the moment, defendants and insurers are keen to come to an early settlement meeting and make offers in final settlement to claimants. To many claimants, those offers are advantageous. But if the Part 36 offer that the defendant makes doesn't offer them any protection, they may be less inclined to leave it on the table. One of the arguments that the defendant raised in SG and Hewitt in the Court of Appeal in favour of the court taking quite a dogmatic approach to Part 36 was, look, on the analysis of the case now, that £500,000 that we offered 2 years ago is a significant overvaluation of the claimant's case. By leaving it on the table through this time, we've allowed the claimant to take about £130,000 windfall on the real value of his claim. And the quid pro quo of that should be that we're then entitled to the cost protection that that offer provides us. The Court of Appeal rejected that, and like the Court of Appeal do, they rejected it not on any kind of pragmatic basis, but on a very kind of intellectualised basis. And so what they said is this: it's perhaps helpful to analyse the decision that would have faced the court if approval had been sought when the offer was originally made in 2009. The court would have been concerned to ensure that the claimant was obtaining proper damages for the injury he had sustained, not only for his pain and suffering, but also taking into account the probable impact of the injury on his earning capacity and on his ability to look after himself independently. If the offer was not accepted and the claimant waited to see how his brain injury evolved, and in fact developed significant problems, as the expert warned that he might, he would recover damages at trial which would compensate him for this. Suppose, however, that he waited to see and problems did not develop, and suppose that the offer had meanwhile been withdrawn. He would not recover as much as the £500,000 that had been available, but equally he would not require compensation at this level because time would have demonstrated that his injuries were more limited. He would therefore have lost what the defendant has termed a windfall, but he would have recovered damages commensurate to his injury. Well, that's great. And it's really nice for the lawyers that in those circumstances their costs are protected. And I like the sort of, on an academic basis, it's an obvious analysis by the Court of Appeal. But if you're a claimant lawyer now, you've got a real problem. Defendant comes along at an early stage where prognosis is uncertain and makes you an offer that buys part of the risk of future deterioration. In other words, we are prepared to overcompensate your claimant on the assumption that the prognosis is not going to get any worse now. If you turn that offer down at that point, you run the risk, I think, as a result of SG and Hewitt, that the defendant will leave the offer on the table and then withdraw it. And when the offer then reappears, the prognosis has become more certain and you've got a much lower offer on the table. And the average claimant doesn't care if they're being overcompensated. They're quite happy to take the money. And you're going to see, I think, much more tactical offers by defendants as a result of this, because they've had what they thought was a certain protection taken away from them. And you are going to have some explaining to do to your claimant clients when they've watched 130 grand walk out of the door over a 2-year period.